Joint account holders. Joint accounts are opened in joint names of more than one persons. So when an account is opened in the name of more than one person, it is called a joint account. When a joint account is opened with a banker, he should take precise instructions in writing as to which member are entitled to draw checks, whether the balance in the account has to be paid to the survivor in the event of death of any of the parties, or whether it is to be dealt with in any other manner. So when a joint account is opened, the account holders must give correct instructions in writing to the banker who will draw checks, then whether the balance in the account will have to be paid to the survivor in the event of death of any of the parties or not. This written document should be signed by all the parties in whose name the joint account is opened. The written document should be signed by all the joint account holders. What are the precautions to be taken by the banker at the time of opening a joint account? A joint account application. So a joint application signed by the all the account holders must be duly signed by all the persons, must be obtained by the bank for opening a joint account. Mode of conduct. The mode of conduct of the account has to be finalized with the consultation and consent of all the members of joint accounts. How the account should be operated, who will operate the accounts. Such things must be finalized by the bank with the consultation and consent of all the members of joint accounts. Appointment of an agent or attorney. The banker should ensure that an agent or attorney may be appointed with the consent of all the joint account holders. Only with the consent of all the account holders, the banker can appoint an agent or attorney. Countermanding order. Any joint account holder can issue the stop payment order of a check to the bank. So when such an order is received by the banker should obey the order. Fifth one, authority to overdraw. The banker should also get a proper authorization as to whether the persons authorized to operate a joint account are authorized to overdrew the accounts. Then revocation of authority. The authority to operate the joint account can be revoked by any of the joint account holders. Death of a joint account holder. In case the joint account is opened with the clause either or survivor, the banker is bound to pay the credit balance available in the account to the survivor. Okay, when a joint account is opened with the clause either or survivor, the banker should pay the amount in the credit of the account at the time of death of the joint account holder to the survivor. Insolvency. In the event of insolvency of a joint account holder, the operations on the account will cease, and payments from such an account should be made only at the joint direction of the insolvent account holder and the solvent party. Joint instructions received from the insolvent account holder and the solvent party. Then the next special type of customer is partnership firms. So what are the precautions to be taken by the banker at the time of opening an account in the name of a partnership firm? First one is letter of introduction. The prospective customer, that is the partnership firm, should be duly introduced by a person who is already known to the bank. As in the case of an individual, an introduction is required for opening an account in the name of the partnership firm. Examine the partnership deeds. The banker should clearly examine the partnership deed to understand the constitution and other details of the firm. Number of partners. Before opening an account, the banker should see that the total number of partners does not exceed the maximum limit provided by the law. So there is a maximum limit for partners, and the banker should check total number of partners does not exceed the maximum provided by the law. Account in the name of the firm. The account should be opened in the name of the firm and not in the name of the partner or partners. The next one is application. An account in the name of the firm may be opened on receipt of an application from one or more of the partners. Then letter. The banker should obtain a letter signed by all the partners containing the name of the firm, the nature of the business, the names and address of all the partners, the names of partners who are authorized to operate the account, etc. Revocation of authority to operate the accounts. Any partner is empowered to revoke the authority to operate the accounts. Hence, if any such a revocation takes place, the banker must stop all payments. Delegation of authority. A partner authorized to operate the account on behalf of the firm has no power to delegate his authority to another person without the written consent of all the partners. Credit a check into the personal accounts. The banker should not credit a check received in the name of a firm to the personal account of a partner. Admission of a partner. When a new partner is admitted to the partnership, the banker need not stop the accounts if the account shows a credit balance. If the account shows a credit balance, there is no need to close the account when a new partner is admitted to the partnership firm. But the banker should get mandate from the old and the new partners about the mode of operation in future. If the account shows a debit balance, the banker should close the accounts and open a new account by getting a fresh mandate signed by all, including the new partner. At the time of admission of a new partner, if the account shows a debit balance, the banker should close the old account and open a new account by getting a fresh mandate signed by all partners, including the new partner. Next one, retiring partner. It is always better to close the old account and open a new account with the remaining partner at the time of retirement of a partner. Death of a partner. If a partner dies, the firm stands dissolved automatically. Hence, the bank must close the account immediately. Then a new account can be opened in the name of the reconstituted firm after obtaining a fresh mandate from the existing partners. So when a partner dies, it is better to close the old account and open a new account in the name of the new firm after obtaining a fresh mandate from the existing partners. Insolvency of a partner. In the absence of any provisions in the partnership deed, a firm stands dissolved on the insolvency of a partner. So it is better to close the existing account and open an account in the name of the reconstituted firm. The next type of special customer is joint stock companies. Precautions. First one is certificate of incorporation. The banker should check the certificate of incorporation of the company in detail. a detailed verification of a certificate of incorporation is required. Certificate of commencement of business. The banker must examine the certificate of commencement of business to verify that the company is legally entitled to carry business. Memorandum of Association. Memorandum of Association is a document containing the fundamental conditions upon which a company is incorporated. The banker should examine the various clauses of the Memorandum of Association. So, Memorandum of Association is an important document of the company. The banker must check the Memorandum of Association, and various clauses of the Memorandum of Association must be examined by the banker. Articles of Association. The rules and regulations of the company are included in the Articles of Association. The banker must examine the Articles of Association to find out the borrowing powers of the directors and the procedure for mortgaging assets and drawing and accepting negotiable instruments. So, the Articles of Association must be carefully studied before opening an account. Copies of annual accounts. In the case of existing companies, the bank shall ask for copies of annual accounts for the last few years to know the financial and profitability conditions of the company. Copy of resolution. The bank should obtain a copy of resolution of the board of directors, appointing it as the bank of the company. Okay, bank should obtain a copy of resolution passed by the board of directors for appointing the concerned bank as a banker of the company. Borrowing powers of the company. The bank should see that the company borrows only for the purposes stated in the Memorandum of Association of the company. The borrowing powers of the company will be specified in the Memorandum of Association of the company. So, borrowing powers of the company must be checked. The next type of special customer is executors and administrators. Executor is a person who is named in the will of a person to administer the estate of the deceased after his death. Okay, executor is a person who is named in the will of a person to administer the estate of the deceased after his death. Administrator is a person appointed by the courts to administer the property when a person dies without leaving a will. Both the executor and the administrator perform the same duties, that is, to realize the assets of the deceased and pay off his debts. That is the duty of the executor as well as the administrator. The bank should observe the following precautions while dealing with executors and administrators. First one, examination of letter. On the death of the customer, the bank must stop all payments from his accounts. The banker should check the letter of probate in the case of executors and letter of administration in the case of administrators to ensure the powers and functions of executors and administrators. The powers and functions of executors are specifically mentioned in the letter of probate and and in the letter of administration in the case of administrators. So banker should check letter of probate and letter of administration as the case may be. The bank can permit the executor or the administrator to operate the account of the deceased. Opening a new account. A new account might be opened in the name of the executors and the administrators. the balance in the account of the deceased is to be transferred to this new account. Okay, so a new account is opened in the name of the executor or executor, administrator, and the balance in the account of the deceased is transferred to this new account opened in the name of executor or administrator. Joint executors or administrators accounts. When two or more persons are appointed as executors or administrators, the banker should get clear instructions from them regarding the executors or administrators who will operate the accounts. Transfer of funds. Banker should not allow transfer of funds from the account of the estate to the personal account of the executor. Trustees. A trustee is an obligation annexed to the ownership of the property and arising out of the confidence reposed in and accepted by a person or persons for the benefit of another or others and the owner of the property. The person he reposes the trust is called the author of the trust. A trustee is the person whose confidence, whose in whom the confidence is reposed. A trustee is the person in whom the confidence is reposed. The person who for whom from the person for whose benefit the trust is formed is called the beneficiary. What are the precautions required at the time of opening an account in the name of a trustee? Examination of trust deeds. A banker should first check the trust deed to obtain the details like name of trustee, their powers, property of the trust, etc. Trustees act jointly. The trustees should act jointly. They are not competent to delegate the powers unless the trust deed authorizes them to do so. Check signing power. The banker should get clear instructions as to who would among the several trustees sign the checks. Retirement or death. The banker should also check the details of death or retirement of any of the trustees to enable the banker to operate the account of the trust without any confusion. Misuse of funds. It is essential that banker does not knowingly allow the misuse of funds by the trustees. Borrowing power. Bankers should grant loans and advances to the trustees only as per the borrowing powers as specified in the trust deed. Borrowing powers will be mentioned in the trust deeds. So, bankers should grant loans and advances to trustees only as per the borrowing powers as specified in the trust deed. Examination of registration certificates. In the case of charitable trust, the banker should verify the registration certificate issued by concerned authorities. Clubs and associations. Clubs, societies, charitable and religious institutions, libraries, schools, colleges, etc., not engaged in trading activities, maintain their account with the banks. So, what are the precautions to be taken by the banker at the time of opening an account in the name of clubs and associations? First one, this society must be incorporated. Okay, the banker should ensure that the applicant society is a properly incorporated body. Rules and bylaws of the society. The banker should examine the rules and bylaws of the society before opening an account. Resolution of the managing committee. For opening bank account, the managing committee of the society must pass a resolution, and resolution must mention the appointing the bank concerned as a banker of the society mentioning the name of persons who are authorized to operate the accounts and giving any other directions for the operation of the account. So, a resolution passed by the managing committee for opening an account must be clearly thoroughly checked by the banker before opening an account. Borrowing powers of the society. In case of a registered society, in case a registered society intends to borrow, the banker must ascertain the borrowing power of the society from its charter or memorandum. Death or resignation. In case the person authorized to operate the account on behalf of a society dies or resigns, the banker should stop the operation of the society accounts till the society nominates another person to operate its accounts. Transfer of funds. The banker should see that the funds of the society are not transferred to the personal account of the trustees who are authorized to operate the accounts. Drunkards. If a person who entered into a contract is not in a position to understand facts, law protects him by making the contract invalid. So, the banker should not enter into any contract with a person if he finds the person under the effects of liquor. Banks should not grant loans, make payments, etc. If it is unavoidable to pay the check, it is advisable to the banker to get a signature of a witness for the payments. Lunatics. Lunatics are persons of unsound minds. They cannot understand what is happening around and cannot think rationally. So bankers should not allow such persons to open an account with the bank in their name. If an account holder becomes insane, the banker should not stop all types of operations. The banker should stop all types of operations of the accounts and all dealings with him as soon it comes to the notice of the banker. Married woman. A married woman can open a current account and operate it on her own like any other customer. If a married woman overdraws the account, and gets a loan from the banker cannot get a repayment from her if she does not have a separate property in her name. The banker cannot recover debts from her husband's property. ഒരിക്കലും ബാങ്കർക്ക് ഒരു മാരീഡ് വുമൺ എടുത്തിരിക്കുന്ന ലോണ് അദ്ദേഹത്തിൻ്റെ ഹസ്ബൻഡിൽ നിന്നും ഈടാക്കാൻ വേണ്ടി പറ്റില്ല. അപ്പോൾ ഈ വ്യക്തിക്ക് ഈ പെൺകുട്ടിക്ക് തന്നെ അതിനുള്ള കപ്പാസിറ്റി തിരിച്ചടക്കാനുള്ള കപ്പാസിറ്റി ഉണ്ട് എന്ന് ഉറപ്പ് വരുത്തിയതിനു ശേഷം മാത്രമേ ലോണ് കൊടുക്കുവാൻ പാടുള്ളൂ. What are the precautions to be taken? He should know the intention of opening the current accounts. Banker should know the intention of opening the current account in the name of a married woman. The banker is safe as long as the current account has a credit balance. If she applies for a loan, the banker should find out the reason for applying for the loan. For what purpose the loan is applied. He should make a detailed enquiry about her personal property. Banker should make a detailed enquiry about her personal property. Fifth one, the banker should confirm that she has the right to sell the property. It is always good to make her husband also liable for repayment of the loan. Joint Hindu family. Joint Hindu family is governed by the Hindu law and Hindu Succession Act 1956. According to the Hindu law, Karta of the family will have implied authority to make decisions and execute it. Hence, the banker should be very careful in dealing with such accounts. The banker can open a current account in the name of a joint family. Karta of the family opens an account and operates it. While sanctioning a loan, the banker should take care about the property owned by the family and rights of male members of the family. It is legally sufficient if Karta signs the document for loan, as the Karta has an implied authority to borrow. But due to the risk factor, the banker should get the signature of all the male members of the family. Signature of Karta is sufficient, but it is better to get the signature of all the male members of the family. If there is a minor member in a joint family, his guardian must sign the document on his behalf. While opening an account by Karta, the banker should obtain a statement from the Karta specifying whether the deposited amount is from joint family property or his personal and self-acquired property. Non-trading companies. Companies limited by guarantee are established for the promotion of health, education, art, social welfare, etc. The liability of members will be limited by guarantee. When such a company applies for an advance, the banker should examine its powers. Only after satisfying with the provisions, the banker should sanction loan. Illiterate persons. Illiterate persons cannot sign their names and hence bankers take thumb impression as a substitute for signature and also a copy of their recent photograph. The application from the applicant and the photograph should be attested by an approved witness. For withdrawing money, he must attend personally and affix his thumb impression in the presence of an official of the bank for the purpose of identification. For withdrawing money by an illiterate person, he must attend personally and affix his thumb impression in the presence of a bank official for the purpose of identification. Okay, thank you.